Ontario lawmakers have been busy increasing protections for workers. But what does this mean for you? I'm Erin Brandt, co-founder and lawyer at Porta Law. There are 3 significant employment law updates from Ontario that you should know about. 1. Ontario employers can no longer ask an employee to sign a contract which includes a non-competition agreement, except in very limited circumstances. This means that unless an employee is an executive or became an employee of the business after selling it, an employee can't be required to agree that they won't compete with their employer after their employment relationship ends. An employee can still be asked to sign a confidentiality or a non-solicitation agreement. Number 2, employers with 25 or more employees in Ontario are required to have a written policy on disconnecting from work. Although the legislation is vague on what specifically must be included in this policy. Number 3, Ontario courts have made it more difficult over the last few years to enforce termination provisions in contracts. It's complicated, and the courts are still continuing to issue clarifying decisions. But the most important thing you should know is if you have employees in Ontario, you should have your employment agreements regularly reviewed to ensure your termination clauses are as up to date as possible. We work with many clients who employ workers in BC and across Canada, and we're happy to answer your questions about Ontario workers or connect you with one of our Ontario partners. If you are struggling with these new Ontario requirements, please leave a comment below.